Ever wonder how much power the state has to remove your child? Texas might shock you. CPS only needs reasonable cause to seek court-ordered services or child removal. This standard is much lower than other civil cases. Worse, if parents don't follow court-ordered services, it becomes evidence to justify taking their children. In 2023, Texas CPS investigated 180,000 alleged abuse and neglect cases. That's countless families facing a system with limited due process protections. And the main protection against overreach are the judges who oversee these cases. They're the critical check on a CPS power determining what proof is needed to protect parental rights. And this is why your Waller County Court at Law number 1 vote matters. We asked each candidate, what burden of proof should CPS meet before ordering services or removing a child? Their answers could shape the balance between family rights and child protection.
Most people do not realize that the Family Code addresses involvement of the Texas Department of Family and Protective Services, CPS, in family matters and provides thresholds that must be met at varying stages of the department's involvement. The thresholds are met by presentation of empirical, tangible, and objective evidence that supports a finding by the court that the department's intervention has met that threshold, and the case should move forward to the next threshold. The department bears the burden to submit the evidence that the threshold has been met before moving to the next stage of the involvement. As a case moves from an initial inquiry to a temporary removal from the home to potentially a final removal from the home, the threshold increases. One consistent thing against which all thresholds are measured is the current physical or emotional harm or imminent physical or emotional harm to the child, which has or will occur based on the empirical, tangible, and objective evidence presented to the court and its ruling.
Texas law sets these standards. We have due process for a reason. As a judge, it's your job to enforce due process. For emergency removal, the standard is there must be imminent, immediate danger to the child's physical health or safety. Immediate means immediate. If it's something that can be handled with notice to the parties, then it should be handled with notice to the parties. If it's a genuine emergency, then it should be handled immediately. If we can get a guy in jail in front of a judge within 48 hours, I think we can manage the same for emergency situations with families. With that being said, if it's not an emergency situation, then they ought to be given time to get notice, get legal counsel. For the department to assume control of a child, they need preponderance of the evidence, 51%, more likely than not. It doesn't mean, well, they might be onto something. As a judge, it's my job to hold CPS to its actual burden. The most important one, of course, is clear and convincing evidence. That's the highest burden possible in a civil case, and that's what's required for the termination of parental rights. The only thing higher is throwing somebody in prison beyond a reasonable doubt. And as a prosecutor, I hold government agencies to their standard. If I can do it, they can do it. One thing we're not afraid of telling these government agencies, you don't have enough. You need to come back with more. And if you can't come back with more, then we don't have a case. I'm certainly not afraid to hold government agencies to their standards, and I think those standards should be met. They exist for a reason, and it'd be my job as judge to hold people to them.